baliisizza amendment 2025. Etteka eryo lituta emyaka 2 basemba dikwatako 206 ne tututa emyaka 2 nga tugezako kola ntukola amendment. Etteka lino ligenda kuyamba abantu abakola digital work nga mmwe, ligenda kuyamba nga nze, ligenda okuyambako abantu abayimbedde ennyimba zaabwe ne zibeera nga abantu uploadinga nga tebazifunyeemu, so bagenda kuleeta kye bayita take down mu tteeka lino. Etteka lino ligenda kukendeezaako ku bantu badde bakozesa emirimu gy'abantu nga tebasasula, nga TV stations, radio stations zibadde tesasula royalties z'abantu, so balina okusasula CMOs, hotels, discos, nightclubs, ebifo ebityo ebikozesa emirimu gy'abantu girina okusasula, kubanga omuntu ayiiya atunda obubuzi bwe nakola ekintu ekirungi. So etteeka bwe baliteekawo ligenda kuyambako abantu abadde babonaabona nga balina emirimu gyabwe naye nga tebagifunamu.
Mulimu abayimbi nga bo bakola copy and paste.
Anti kigenda bakosa bwe kiti. Ekigambo copyright kitegeeza nti tojja kukosa intellectual property y'omuntu. Waliwo ennyimba z'owulira ng'olimba ddala lulimba oli ayimba olimba olutali lulwe. Waliwo kye bayita moral rights. Kakati rights ezo z'omuntu ddala gy'otula nti olulimba si lulwo ne n'oluyimba oba n'okola n'okwata endongo efaanana ng'ey'oli n'ogifulumya, bigenda kufuuka bizibumu. Kuba kati tulina gye twandiisenga kkooti yaffe ku URSB, Registrar General aweereddwa amaanyi kati okubeera nti asobola okutereeza disputes. Oli bw'agamba nti oluyimba lwange balukopye n'abawozesa nga temunagenda na mu kkooti. Ekibadde kiremye abayimbi abasinga, omuntu ayagala akubba oluyimba nga kimanyi tolina ssente zigenda mu kkooti. Then waliwo abantu abalala abayimba ennyimba edda long time ago, nga oluyimba lwe balugula $1,000,000 ng'ate kati ebbanga lino yandibadde anaku $1,000,000 nga 100. Kati etteeka ligenda kuyambako omuntu nti oli gwe bakola ddiiru enkyamu, waliwo abantu bangi babagulako album $1,000,000 naye nga $1,000,000 tayinza nagula capati. Kakati essaawa eno etteeka ligenda kuyambako oyo yanyigirizibwa okubeera nti afunamu. Andi bagyemulugunyizaako olwo sigenda kyogera bwe nti bagyemulugunyako olw'obo okubeera nti waliwo okumanya n'okutegeera. Buli akozesa emirimu gy'omuntu aba nakyajagaza. Toyinza kubeera na TV n'oteekako ekifaananyi ky'omuntu nga tokyagala. So abalina TV nga balina okusasula kye bayita royalties, abalina radio nga balina okusasula ennyimba z'abantu ze bakozesa. So radio ezisinga zibadde zikozesa bya bwereere. Nzijukira mu 2021 eggulu twasayininga contract n'aba NAB, National Broadcasters, nga twagala basasule bannabitone. Ne bo baali bagamba ate lijja bisasulayo. Ne kakati etteeka lino etteeka lino ligenda gamba buli alina TV, buli alina radio, buli alina kyakozesa nti mu club agenda kusasula abantu bano.
Kati oba nalekerawo okuba ennyimba zammwe.
Beba nakola ki?
Oba nalekerawo okuba ennyimba zammwe. Oba music omulala wali ng'owa Nigeria.
Anti waliwo mu CMO kye bayita reciprocal agreement. Waliwo bwe tugenda mu mateeka amakulu gennyini, waliwo kye bayita ban convention oba ban treaty. Uganda is part of that. Tusayininga reciprocal agreements. Agreements ezo zikkiriza okubeera nga tusolooleza n'aba Nigeria. Era zikkiriza tusolooleza amawanga gonna agali mu reciprocal agreements ezo aba falling into the ban convention, abali mu Beijing convention treaty, abali mu Marrakesh. Ebyenjogera bya mateeka nnyo naye omuntu alina kuba nga abitegedde, kuba nti buli luyimba olukubibwa lubaako nannyini waalwo.
Jajalagadde etteeka lino litandise okukola kati nga balimaze okuyisa
wetuviiridde omuntu akutwalira mu kkooti bikolerawo, kubanga bwe bamala okuyisa etteeka kiba kigenze in action. Kati abantu abasinga njagala bagamba nti abantu bangi nnyo balina emikutu, bataddeko ennyimba z'abantu, bataddeko firimu z'abantu, naye bo be bafunamu. Kati essaawa eno yakusasula.
Bananyini mativi we yongera basasuza obulango bw'ebivulu biki mugenda bamwe mukikola muti.
Andi kigenda kuba bwe kiti. Bananyini TV na tebasobola kukola TV zaabwe nga tebakozesa content. Kakati bagenda kubeera nga bategeera nti bwe tusasula royalties katukozese bulungi nnyo emirimu gy'abana abantu betusasula.
Abantu nga Jajalagadde olimba ndigida sise leta bamuzeyi Sebatta dole y'omwana ezo ennyimba enkadde. Bo bagenda sifunamu batya oba kikiwedde tandika ku bipya ebiriwo kati.
Oluzannyirako ndaba abaana abato ababuukira ennyimba z'abantu. Oluzannyirako oluyimba lw'omuyimbi omukadde manya nti ojja kusasula bulungi.
Jjajjalagadi ate abaali batunda album zaabwe.
Anti kyekugambye emyaka 2 mu tteeka mu close eyo gye bataddeko eya Bagain. Waliwo abantu be bakosa ensonga enkyamu ne baba signingisa ebipapula ebikyamu ne babatwalako rights zaabwe. Kati rights zigenda kudda.
Tekigenda kudda kufuuka kintu kizibu nnyo upcoming okuba akajji kati.
Upcoming kyangu nnyo kuba akajja ayimba ebibye.
Abasemba muteeka lye bayisizza singa omuntu oyo okuwa engasi naddala gwabawaadi
kiri bwe kiti bwe twali tukola etteeka eryo tulikola kambabulire gye tuvudde etteeka tulirwaniridde emyaka 11 muyinza okuba mulaba bya tteeka abantu abaogana ku paliamenti mbaddeko Harare mu Aripo mbaddeko Switzerland mu Waipo mbaddeko e Nigeria mbaddeko e Ghana mbaddeko e South Africa ku tteeka etteeka lino kye ligenda okukola kikino tubadde tuna currency points mumpulirize bulungi currency points 105 nga kyekibonerezo omuntu kyalina ng'omuntu ayinza okukopola vidiyo yo nakusasula akakadde naye nga akadde byatawuseemu 2000 points kitegeeza olina kusasula miliyoni nga 2.3 kakati miliyoni 2.3 vidiyo y'omuntu ojja gireka. Yes.
Clause 7 in relation to amendment to section 14 L be left to read the work is used in an online learning environment by an education institution, library, archive or museum, full stop, but not for the beneficiary person or other than for commercial use.
Chair.
Madam Chair, the Attorney General should then explain how you protect access of published works by persons who are blind, visually impaired, or otherwise print disabled. How do you protect them?
Thank you. Chair. Of course, government currently, when we are dealing with our education institution, we take into consideration all the needs of all the persons, even those ones who are visually impaired, those who are impaired in any other way are provided for. So when you say for educational purposes, it is not, it is encompassing all the person in the education.
Attorney General, K protects what is asking about.
Fair enough. I'm
you
read
K.
K.
K on the bill.
In the bill.
Yes.
Does it?
It does protect.
I concede.
Okay. Attorney General, for avoidance of doubt, just restructure your statement, the amendment.
Right, Honorable Speaker, we propose that clause 7 of the bill stands as it is in the bill currently, and that the proposal made by the committee should not be adopted, because section 4, clause 14 properly caters for all educational purposes for which the copyright could be used. Beg to submit.
Thank you. I put a question that clause 7 stands part of the bill. Those in favor say, and the contrary, the ayes have it.
Clause 8.
Chair.
Madam Chair, the committee proposes amendments to clause 8, which is amendment of sections 14 and 14 being the principal act in the following terms. Clause 8 is amended in the proposed section 114B2 by inserting immediately after the word found the words identified or is unknown. Justification to harmonize the provision with the definition of the phrase orphan works in clause 1 of the bill.
Right, Honorable Speaker, Right, Honorable Chair, and Honorable colleagues, yes, we do concede that the proposal as made by the committee widens the scope of orphan works and clarifies it as defined in clause 1. We concede to the amendment by the committee.
I put a question that clause 8 be amended as As proposed, those in favor say and the contrary nay. The ayes have it.
Clause 8 as amended.
I put a question that clause 8 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 9.
Clause 9. Honorable members, I am in receipt of a letter from one of the members pursuant to Rule 140, Sub-Rule 4 of the Rules of Procedure, and the member is Honorable Kabanda on the amendment of Clause 9. And I will invite Honorable Kabanda to move his amendment.
Right Honorable Speaker, thank you so much for allowing me to make some amendments on Clause 9. As you have said, I wrote to you on the 9th of March 2026 notifying you about my intentions to move an amendment to Clause 9 of the bill pursuant to Rule 140 Sub-Rule 4 of the Rules of Procedure. Right
Yes,
Honorable
go
Speaker,
ahead.
I was unable to submit to the committee because by the time the bill was under consideration, I was away on official duty. Right Honorable Speaker and honorable members, I beg to move the following amendments to Clause 9 of this bill. Right Honorable Speaker, I move that Clause 9 be substituted for the following. Section 30 of the Principal Act is amended by A. I am by substituting for the proposed subsection 1, where a sound recording or audiovisual fixation published for commercial advertisement purposes or a reproduction of that sound recording or audiovisual fixation is used directly or indirectly by broadcasting or other communication to the public, or is publicly performed unless otherwise agreed. An equitable remuneration determined by the minister in consultation with the registrar and relevant stakeholders for the performer or performers and the producer of the sound recording or audiovisual fixation shall be paid by the user to the author for every use of the work. B. By inserting immediately after subsection 1 the following. The remuneration referred to in subsection 1 shall be paid through a payment system established under the National Payment Systems Act. B. 1B. The registrar shall, for purposes of this section, monitor the use of a sound recording or audiovisual fixation for commercial advertisement purposes or for broadcasting or other communication to the public and send periodic reports to the minister. Right Honorable Speaker, 1C, the minister may, in consultation with the registrar and any relevant stakeholders, by statutory instrument, prescribe the procedures for collecting, distributing and receiving royalties and other entitlements from use of copyright or neighboring rights. Just to justify, to streamline the procedure for collection, payment and distribution of royalties to the author. I beg to amend.
Thank you, Chair.
The committee did not propose any amendment to this clause because this clause, the purpose of the clause was to require any person who uses or entity who uses copyrighted materials for commercial purposes to pay a levy. This will enhance revenues for our creatives. It will expand the industry and it will help energize and enhance the work of our creatives. So that purpose has not been lost in this amendment. I have noticed that the amendment still maintains that purpose. What I've noticed in the amendment is just streamlining who is going to determine the equitable payments, because equitable is subjective. So to avoid ambiguities around the issue of equitable payments, this amendment seems to clear that. It says the minister, in consultation with the Registrar General and stakeholders, the stakeholders being the creatives through their CMOs. And then the other one, I think, was on how payments will be done through a system that is well known to us through the bank, such that money is not, you don't just go to a radio station or an entity and you are given money in a bag. The money should go through a system that is established. So I concur with the amendment. It does not change the substance of the clause, and so as a committee I think we are okay with it.
Thank you. Eddy.
Thank you, Right Honourable Speaker. Right Honourable Speaker, upon receipt of your notification of this amendment, we did have a chance to consider this and even had a chance to discuss with the stakeholders who are available on this. We have no objection to this amendment.
Thank you. I put a question that clause 9 be amended as proposed by Honorable Kabanda, agreed with the chair of the committee and confirmed by the Attorney General. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 9 as amended.
I put a question that clause 9 as amended stands part of the committee. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 10.
Clause 10. I put a question that clause 10 stands part of the bill. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 11.
Madam Chair, clause 11, the committee proposes amendments.
Before you go to clause 11, I can first introduce our guests who are up there. We have Eddy, Kenzo Musuza. You're welcome. Karonji Shiva. Pius Palazzo. Joseph Mayanja. Chameleon. Moses Saleh. Martin Moomuza. Michael Kalumba. Lillian Mbabazi. Lord Fred Sebata. Alex Lokuten. Cindy Sanyo. Daniel Kazibwe. Ragadi. Pastor Wilson Bugembe. Pastor, where is Pastor? Martin Musoke. Anitah Kawalia. Matthew Nabwiso. Nathan Magola. Cassandra Richard. Kansime Ann. Anet Nanduja. Aisha Nava Ziwa. Sewanya na Malcolm. Raymond Kaisa. Richard Mugisha. Shine Nyashosh. Okuni Edward. Sulaiman Lwanga, Halima Namakula, Mzee Eddy Masawa, Ronald Mainja, Charles Musoke, Cheyune Mohammed Habib, Nkalubo Rona, Lubega Idris, Chachimwa Jen, Agaba Ezra, Exodus, West King, Emrys, Bruno, Kamugisha Abia, Sendi Jafaruk, Muinda Rao, Fanta Busoga, Kabi Fred, and Kironde Vidi. You're all welcome. Join me in welcoming them. We also have our own Hilda man. We also have our own Obanga Ina. We also have our own we have Balam. And then we have Orone. Chairman Orone. Chairman and then we have Chairman Kayemba Solo. You're all most welcome and thank you for coming. Silo. We also have Silo. Honorable members, can we finish the bill? In the VIP gallery, we have Honorable Margaret Tilu, a Member of Parliament elect Amuria. We have Honorable Emmanuel Baira, Blambuli County. We have Honorable Kainza Agnes from Budoda. We have Honorable Wanyoto Godfrey from Budadiri West County. You're all most welcome and thank you for coming. Clause 11.
Clause 11.
Madam Chairperson.
Clause 11.
Clause 11.
Madam Chairperson, Clause 11 is an insertion of Section 39A in the Principal Act. Clause 11 is amended in the proposed Section 39A, 39AA in subsection 2 by substituting for paragraph A the following: A, author 30%. 2, by inserting immediately after the paragraph A the following: performer 30%. B, by inserting immediately after subsection 2 the following new subsections: the remuneration to be paid under subsection 2 shall be computed on the net revenue earned by the person exploiting the works of the author or the performer as collar ringback tone after payment of any applicable taxes. A contract for exploiting the works of the author or performer as collar ringback tone in existence before the commencement of this act shall continue in existence as if the same was made under this act, except that the remuneration under the contract shall be the rate prescribed under subsection 2. Justification, Madam Chair, to assign the author and performer separate entitlements, since each has individual rights in the copyright over collar ringback tones. Second justification, to extend the validity of contracts for collar ringback tones and require the payment of rates prescribed under the bill. Finally, justification to specify for clarity that the remuneration is based on the net revenue after tax. I beg to move.
Thank you. Eddy.
Thank you, Right Honourable Speaker and Honourable colleagues. We have no objection principally to the amendment as it aligns with government's policy to protect the creatives in the industry. Just Right Honourable Speaker, in line with the proposed amendment clause 9, we propose that the remuneration to be paid under this clause, under clause 11, be paid through the payment system provided for under the NPA Act. National Payment Systems Act.
Amendment.
So I'm proposing that consequent to the amendment in clause 9, we amend clause 11 to include that the payments made under this clause shall be made through the National Payment System as prescribed under the National Payment Systems Act. I beg to
Thank you. I put a question that clause 9 be amended as proposed. Those in favor say on the contrary, nay. Those in favor say on the contrary, nay. The ayes have it.
Clause 11 as amended.
I put a question that clause 11 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 12.
I put a question that clause 12 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 13.
I put a question that clause 13 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 14.
I put a question that clause 14 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 15.
I put a question that clause 15 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 16.
I put a question that clause 16 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 17.
Chair.
Madam Chair, Clause 17 is insertion of Section 49A in the Principal Act. Clause 17 is amended in the proposed Section 49A by substituting for the subsection 4 the following. The registrar shall not issue an order or a notice for blocking, taking down, or obstructing of infringement content unless the owner of the copyright proves that an infringement of copyright works has occurred as required. Justification to harmonize the proposed subsection 4 with section 45 of the Principal Act, which describes an infringement of copyright and neighboring rights is deemed to take place. Second justification, the certificate of ownership is not proof of infringement since it does not contain the copyright alleged to have been infringed. The proposed subsection 4 is amended since it has the effect of introducing mandatory registration of copyright works in contravention of the provisions of section 3(1) and 2 of the Principal Act and principles prescribed under the World Intellectual Property Organization framework, which grants blanket protection to any copyright works without any formalities such as registration. I beg to move, Madam Chair.
Eddy.
All right, Honourable Speaker and Honourable colleagues, we do appreciate the spirit that the committee raises here. However, a clear reading of the entire clause 49 shows that there is a process that you must undertake before a taking down of the works is concerned. However, I am concerned with the reading which says the has occurred as required by section 45. Right Honourable Speaker and Honourable colleagues, the exercise of copyright activity is not necessarily one that should go to court, because if the owner of the works comes and says that person is using my work without my permission, the registrar should be at liberty to take that down. But if we start talking about proof, then we are saying we have to first go to court, how long it's going to take in court, and etc. After all, the person who has put up the works, if they have a valid claim over those rights, they can still have them enforced. So I propose that the amendment proposed here, it places an onerous task on the owner of the copyright to prove infringement, whereas all they need to say is that I did not authorize you to use my works. And the provision as we have it here, Right Honorable Speaker and colleagues, I think covers that. I propose that that proposed amendment be dropped and clause, Right Honorable Speaker and colleagues, I think covers that. I propose that that proposed amendment be dropped and clause 17 of the bill does stand as proposed.
Chair.
Madam Chair, the original clause 17 requires that work, not registration. So if you leave here registration as a condition for the registrar to take down the works that have been infringed upon, then you are saying the creatives must go and register their works, which you are saying no, they don't have to register their work, because that right accrues as soon as you produce a work, the right accrues, you don't have to register. So the only way out is for the rights owner to go and prove that they are the ones who produced that work, not a certificate of registration.
Right Honorable Speaker.
Must register.
No. The right.
The right,
because
that is okay.
There are rights that accrue upon registration.
Yes.
But whether I've registered or not, I am the copyright holder.
Yes.
Yes.
But
and whether I've registered, Madam Chair,
as a creative.
Madam Chair, and whether I've registered or not, I am protected under the law. Yes. I am protected under the law.
Order.
Right Honorable Chair. The Honorable Member is correct that once a creative produces his work, he has a right to that work. But for you to benefit from the protections provided by the law, you must register. Yes. Because you will find it very difficult to tell someone that they're infringing your rights when they did not know they were your works. So you need to register your rights in order for you to protect yourself under the law.
Because anyone can claim. You must register.
Your right exists by virtue of your permission.
Honorable.
Attorney General, so I concede.
I put a question that the I put a question that clause 17 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 18.
I put a question that clause 18 stands part of the bill. Those in favor say the ayes have it.
Clause 19.
19, Chair.
Clause 19, there is a proposal by the committee. Clause 19 is Clause 19 is amended by deleting paragraph B. Clause 19 is amended by deleting paragraph B. Justification, Madam Chair. The proposed subsection 3 is redundant in light of Section 45 of the Principal Act, which describes when an infringement of copyright and neighboring rights is deemed to take place. The proposed subsection 3 is deleted since it has the effect of introducing mandatory registration of copyright works in contravention of the provisions of Section 3(1) and 2 of the Principal Act and Article 5(2) of the Berne Convention and Article 20 of the World Intellectual Property Organization Performances and Pornographs Treaty, which the bill seeks to domesticate, which prohibit the imposition of formalities on both the enjoyment and enforcement of copyright works.
Eddy?
Thank you, Right Honourable Chair. Right Honourable Chair, we propose that subclause 3 remains part of the bill. Subclause 3 as proposed by government is that the adequate evidence referred to in subsection 2 may include a certificate of registration. Right Honourable Speaker, Right Honourable Chair, the import of this provision is that the moment a creative produces a certificate of registration, that is adequate evidence that they are the owners of that copyright from the registrar, the copyright registration. So to remove it, this proposal was being made in line with the proposal to amend clause 16. But since clause 16 did not pass, we propose that clause 3 of the principal bill do stand.
Madam Chair, after what we have agreed upon in the previous clause, which was clause 19, clause 17, clause 19 consequentially has to remain as it was. So I concur with the Attorney General.
I put a motion that clause 19 stands part of the bill. Those in favor say and the control nay. The ayes have it.
Clause 19 as amended.
There is no amendment.
Clause 20.
Madam Chair, clause 20 is on substitution of subsection 56 of the Principal Act. Clause 20 is amended in the proposed section 54 in the following terms. In subsection 1, by substituting for the words a group of persons, the words any 30 or more people. B, in subsection 2, by inserting immediately after paragraph A the following new paragraphs: a copy of articles and rules of the collecting society. After paragraph A, the following new paragraphs: a copy of articles and rules of the collecting society, a copy of the certificate of incorporation as a company limited by guarantee without share capital issued by the Register of Companies, and C, by substituting for subsection 3 the following: the registrar shall not register any two collecting societies in respect of the same band of rights and category of works.
Any two or more than.
Justification: to group the persons as used in the bill is ambiguous and will force enforcement challenges, since it is not certain as to how many people are required to establish a collecting society. The other justification, Madam Chair, to harmonize the provision with section 58 of the Act, which require a collecting society to have 30 people as a minimum. To require collecting societies be incorporated by the Register of Companies and regulated by the Register of Copyright in order to separation incorporation of collecting societies, in order to separate incorporation of collecting societies and the regulation of their operations. To require collecting societies to be not for-profit organizations, and to restrict the registrar to only register not more than 2 collecting societies for each bundle of rights. I beg to move, Madam Chair.
Eddy?
Thank you, Right Honourable Chair. Right Honourable Chair and honourable colleagues. the committee proposes to amend clause 20 by inserting immediately after a group of persons any 30 or more people as who intend to operate a collecting society. Right Honorable Speaker and Honorable colleagues, this bundle of rights are different. You have musicians, you have artists, you have now new groups called TikTokers, you have YouTubers, you have bloggers, you have all manner of people. And to say that there must be 30 crafts, to say that there must be 30 to create a collecting society for a bundle of rights is wrong. Because that means that if there are only 3 who do that activity, then they can't be paid. So we are saying any group of persons who intend to operate will apply and register, so long as the registrar shall not register more than one group for each bundle of rights. And whether they are 5, 10, 100, that's one bundle of rights. And therefore that proposal will create a challenge for the artists, especially if we want to write a law which is going to surpass time. Things could change. Secondly, Right Honorable Speaker, Right Honorable Chair, the provision as proposed by government is that for you to register, you provide a copy of the constitution specifying the objects of the society as specified in section 57. To ask them to provide a copy of the articles and rules of the collecting society, a copy of the certificate of incorporation as a company limited by a guarantee without share capital by a registry of companies is duplicity. The moment they are registered and they have their constitution, let us allow them to take the form that they wish to take depending on the circumstances of their business. So Right Honorable Speaker, Right Honorable Chair, I propose that clause 20 stands as part of the bill without the amendment as proposed by the committee. I beg to submit.
Chair.
Madam Chair, this morning while interacting with some members of the creatives in our consultation, this matter came up. Although we didn't discuss it thoroughly, I had an opportunity to discuss it further with some of the members, and their ideas seemed to be in line with what the Attorney General has just said. Number one, that having 2 collective management organizations in one band of rights. For example, if you had for the musicians, if you had the UPRS and then there's another one, it would be an extra cost to the entities.
Why do you take long to? Please.
So the speaker is accusing me of taking long to finish. So the short of it is that the Attorney General, the proposals are in line with the creatives that we had this morning discussing this matter, and I concede.
I put a question that clause 20 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 21.
Chair.
Madam Chair, clause 21, the committee has a proposal to amend clause 21 in paragraph C by inserting immediately after the proposed paragraph BA the following: BB, in consultation with its members to prescribe fees for accessing corporate works owned by its members. Justification to enable collection societies set fees for accessing corporate works owned by its members.
Eddy.
Right Honorable Speaker, Right Honorable Chair, we have no objection. That amendment, it enhances the proprietary rights of the members in those societies. I concede.
Thank you. I put a question that clause 21 be amended as proposed. Those in favor stand the contrary nay. The ayes have it.
Clause 21 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 22.
I put a question that clause 22 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 23.
I put a question that clause 23 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 24.
I put a question that clause 24 stands part of the bill. Those in favor say and the contrary nay. Those in favor say and the contrary nay. The ayes have it.
Clause 25.
I put a question that clause 25 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 26.
I put a question that clause 26 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 27.
I put a question that clause 27 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 28.
I put a question that clause 28 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 29.
I put a question that clause 29 stands part of the bill. Those in favor say and the contrary nay. You have even stopped talking. The ayes have it.
Clause 30.
I put a question that clause 30 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 31.
I put a question that clause 31 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Title.
Clause 1.
Clause 1.
Thank you, Madam Chair. Clause 1, the committee proposes amendments as follows. In paragraph A, 2, in the definition of broadcasting by inserting immediately before the word wireless, the word wire.
Chair, we will approve one by one. One definition at a time. Okay?
Thank you, Right Honorable Chair. Right Honorable Chair, in clause 1, there was a proposed amendment to accessible format, which the committee did not question.
To access what?
Accessible format, format copy.
Yes.
Then we have anonymous work. So the third one is the proposal.
And the third one, the proposal is in the definition of broadcasting by inserting immediately before the word wireless, the word wire or.
Right Honorable Speaker, Right Honorable Chair, we concede to that proposed amendment that wire or wireless widens the definition of broadcasting.
Those in favor say on the contrary nay. The ayes have it. Next.
In 3, in the definition of orphan works, by inserting immediately after the word found, the word or is unknown.
Eddy.
Right Honorable Speaker, we have no objection to that proposed amendment.
Those in favor say on the contrary nay. The ayes have it.
And in 3, Madam Chair, in the definition of sound recording, by inserting immediately after the word thereof, the words whether as stand-alone fixation or incorporated or used in other media after the initial fixation.
All right, Honorable Speaker. Sound recordings as provided in the bill as proposed distorts that meaning. We propose that the definition of sound recording as proposed by the government bill do stand as part of the bill.
I put a question that this stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Madam Chair, 4, in the definition of circumvent a technological protection measure by inserting the following phrase at the end of the provision: without the authority of the copyright owner.
Thank you.
All right, Honorable Chair and members. We cannot possibly write a law to allow anyone to circumvent the law. So even the owner cannot be allowed to circumvent the law. So I propose that the provision as stands in the bill does remain.
Chair, concede.
I think the Attorney General has been quite reasonable.
You want to circumvent?
You cannot allow anyone, including the owner, so I concede.
Okay, I put a question. Those in favor stand the contrary, nay? The ayes have it. Hey, I will drop it.
5 in his
Hey,
by inserting
consequential.
the definitions of inserting the following definition in their appropriate order in the bill. AI, artificial intelligent works,
Drop.
means work generated by an artificial intelligence system through human creative input, direction, and supervision.
Drop it. It collapses. Drop.
The Attorney General will come and make a comment on it. Then
It collapses. It is consequential to the. Yeah, it is consequential.
consequentially. The next one is collective society means an organization approved and authorized by the Registrar of Copyright, which has its main object or one of the main objects, the negotiating for collection and distribution or royalties, and the granting or licenses in respect or the use or copyright works or neighboring rights.
Okay.
Right, Honorable Speaker and Honorable colleagues, the Act itself, the body of the Act already determines the object of a collecting society. It is in the body itself. So to define it here like this would conflict with the object already stated in the law. So I propose that this be dropped.
No harm, Madam Chair.
Thank you.
Because
Next.
the provision on AI,
Graphic coffee.
yeah, the provision on AI is dropped in the amendment, in the definition section.
So next definition. Is that all you have?
Right, Honorable Speaker, there was a provision under the definition of derivative works to include work generated by artificial intelligence. That is also consequential amendment that is going to be dropped. It had been proposed by the committee. The committee also proposes a provision for training data set, means the data set including copyright works used to train an artificial intelligence model system. This again is a result of, as per the discussion we had in respect to AI as a tool, we propose that provision also be dropped.
Okay.
Madam Chair, I missed that page in my report. Been looking for it, I could not see it, but the import of our definition was to make it clearer. So if it, in the view of the Attorney General, the matters are clear, I have no problem. I drop.
Thank you. I put a question that clause 1 be amended as proposed. Those in favor say the contrary nay. The ayes have it.
Clause 1 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say to the contrary nay. The ayes have it.
Motion for resumption of the House.
Honorable Minister.
Yes. Right, Honorable Speaker and Honorable Members, I beg to move that the House do resume and the Committee of the whole House do report thereto. I beg to move.
Thank you. I put a question that the House does resume and the Committee of the whole House reports thereto. Those in favor say the contrary nay. The ayes have it.
Report of the Committee of the whole House.
Honorable Minister.
Right, Honorable Speaker and Honorable Members, I beg to report that the adopted.
I put a question that the report of the Committee of the whole House be adopted by this House. Those in favor say the contrary nay. The ayes have it.
Bills, third reading. The Copyright and Neighboring Rights Amendment Bill 2025.
Honorable Minister.
Right, Honorable Speaker and Honorable Members, I beg to move that the bill entitled the Copyright and Neighboring
Rights Amendment Bill 2025 be read the third time and do pass. Those in favor say the contrary nay. The ayes have it.
A bill for an act titled the Copyright and Neighboring Rights Amendment Act 2026.
Title settled and the bill passed. You can now say what you want to say.
Honorable Speaker, it's one of those times that I get to congratulate the House on passing a bill. This bill was incidentally initiated by we on the opposition side through our Shadow Minister for Arts, the Honorable Hilary Chiaga, who is part of the community. Government did take over the bill and the law does allow, and here we are. Let me say, you know, we pass many bills here, and normally the problem is implementation. So I have seen, and the artists are very excited that the bill has been passed. We are all excited that the bill has been passed. But I hope we are not going to have run-ins when it comes to implementation. That's normally the problem. So the bills gather dust and they're not acted upon. And then the excitement ends up fading. I hope we don't get to that point. That said, Honorable Speaker, the old law of 2006 had regulations of 2010 that came through in 2010. We hope that there will be new regulations to actualize, because now this is an amended bill, so we cannot rely on the 2010 regulations. We hope that there will be regulations that will come through to harmonize and actualize some of the things, because there was still some pettifogging over some clauses and so on, but the regulations help to remedy that. I hope that they will come through soon enough so that then actualizing of this new law gets to happen. With your permission, Right Honourable Speaker, kindly allow a 30-second comment from the Shadow Minister for Arts, who is the initial initiator of this bill.
Honourable.
And he's also part of the community. With your permission, Right Honourable Speaker.
Honourable, don't take credit from what you've not done. Honourable.
No, I've already mentioned we initiated.
Honourable Law, please sit. First of all, I want to thank all the members of Parliament for passing this very important law. I also want to thank you, Honourable Hilary, for the first initiation. I want to thank government for ensuring that the bill came to the House. I want to thank, in a very special way, the Attorney General. I also want to thank the committee for the good work you've done. I also want to thank our stakeholders for being here and following up the law. I want to thank, Kavanda, you said I thank you. Okay, I want to thank Honourable Kavanda and myself. But in a special way, I want to thank all the members of Parliament. And one thing I want to tell our good friends there was no ill emotion, no ill motive on delaying the bill. Now the bill has passed. So will you continue making noise out there? You can now go and make noise that the bill has passed. And we are not ignorant. We have students and teachers from Science High School, Mukono Municipality. You're most welcome. They are here to witness the proceedings. They are represented by Honourable Betty Namboza and Honourable Nabukera Anitah. Most welcome, and thank you so much for coming. The house is at the giant sundial.